Yeah, thank you. Once again, let me make a profoundly important discussion in terms of the distinction between ADR and Ubuntu, which is always another misconception that we have. So I would like to discuss that in terms of how they are operationalized, but also how the two perhaps are intertwined, but not necessarily the same. And that is something you may want to understand in as far as discussion is concerned. So it's important, by the way, to make that distinction because those are the questions that I'm asked. What then is the difference? You're making being a drum major for Ubuntu in terms of constitutionalizing it, but then what is the difference between the two? Listen, the ADR and Ubuntu they share probably the same family resemblance, but are not constitutively identical. ADR Ubuntu is mostly a procedure and contingent, whereas the other is very different in terms of the application. And I'm going to make that argument in terms of trying to make the proper distinction between the two. Because if then that is the position, then it is important that people understand and move in that direction. So listen, Ubuntu, as I said many times, is derived from the Nguni aphorism of Umuntu, Ugumuntu, Ngabantu. A person is a person through other persons. It's not merely a cultural sentiment, it is a fully elaborated philosophical and legal system with the following jurisprudential operative dimensions. I would argue in terms of, for example, rational personhood. The self is constituted through relationships. A person is not fixed in terms of individual endowment, but a relational achievement. So in law, this means that disputes are never merely between two individuals. They involve a web of relationship in which those individuals are actually embedded. And when you look at Thaddeus Mars, in terms of relational moral theory, which I would argue as a binding on Ubuntu, holds that an act is right insofar as it positively relates to persons through care, community, and even solidarity. And that is very true. Number two, you could also add in terms of restorative order, retributive justice. Yes, Ubuntu's justice telos is not a punishment of the wrongdoer, but a restoration in terms of a broken relationship. As Desmond Tutu articulated, Ubuntu needs to seek the healing of breaches, reuniting of the form of fabric in terms of relationship. It's a in formal terms, privileges, remedies that repair rather than merely punish. Okay. In terms of communal dignity, you could argue in terms of Kentian individual dignity, where Ubuntu is looked at as an aspect of community engagement. Relationships in terms of educational rights claims have to be resolved not from isolation of their social context, but in terms of the communal impact. Then look at arguments like in terms of the consensus versus dialogue. Ubuntu's governance favors what they call IDABA, structured community dialogue reaching consensus over majoritarian oppositions. So that's another important. If you argue in terms of the harmony as a constitutional value, Ubuntu demands that the law be oriented towards social harmony. It's not watered down in terms of peace, but substantive harmonization of what competing interests grounded in mutual recognition against the framework, and that is something that is important for us to comprehend. Now, as I said, I want to make a kind of distinction. Now, before I argue that, it's important to note that in terms of the philosophical analysis, Uganda's ADR landscape has to be mapped with precision, and it's not monolithic in this argument, and I'd like to make that proposition as well. Listen, the Judicature Mediation Rule, SI 13-17 of 2013, introduced court annexed mediation as a mandatory step in terms of civil proceedings before the High Court and Commercial Court. Rule 4 particularly provides that at the settling conference, for example, the register shall actually fix the matter for mediation. When you look at Rule 11, a settlement agreement has to be reached in mediation that has the force of a consent judgment. So the Commercial Court's practice, Direction Brass of 2012, and subsequent iterations embedded mediation even more deeply into pre-trial procedure, reflecting that judicial recognition that adversary trials was actually not always the best mode of delivery, and that is something we must understand as a precursor to our discussion this morning. Listen, this legislation originally was enacted in 2000 and revised in 2010. It provides that framework for domestic and international arbitration and conciliation. If you look at the Constitution under Part 4 of the Cap 4, it is particularly Ubuntu resonant, and the conciliator does not impose a decision but assists the parties to reach this mutual or acceptable settlement, preserving the relationship and even dignity, which I must say is a good takeoff in terms of the jurisprudential law. But listen, this act basically established a simplified procedure, for example, for claims in terms of not exceeding 10,000, 10 million, not 10,000, 10 million, with a mandatory mediation before adjudication. So the magistrate conducting small claims proceedings is explicitly empowered to encourage the settlement at any stage. And this is something also that is extremely important in terms of our dispensation of the discussion this evening. Listen, when you argue in terms of the Local Council Court Act, look at Cap 13 as amended, it establishes Local Council 1, 2, and even 3 with jurisdiction over specific civil matters, including land disputes, customary matters, and family issues. So these courts operate largely through communal-based dialogue and consensus presided over by elected community members rather than trained lawyers. Their procedure is fundamentally Ubuntu in architecture, informal, rational, oriented towards harmony rather than legal technically. So we need to comprehend that as well. But again, the purpose is to make that distinction, and that is what I'm about to arrive to. Listen, when you argue in terms of beyond formal ADR, Uganda recognizes or tolerates several indigenous justice systems, yes? Talk about Matoput, yeah? A cleansing and reconciliation ritual that involves acknowledgement of harm, payment of compensation, and even community integration, administered through clan and even community structures. When you look at the Kakoke Mandate, which was another large community assemblies of deliberation and conflict resolution among the Acholi. When you look at Rotkwedi, it's an elder-mediated council in Lango. Look at clan courts across the Baganda, against the Basoga, the Banyoro, the Ankole. They presided over by clan heads, the so-called Batakas, in terms of applying customary law to family land and even succession disputes. These are not merely informal. The Judicature Act, Cap 13, and the customary, for example, Marriages Registration Act implicitly recognizes their output, and even courts have actually repeatedly defended the clan-mediated settlements. And that's something beautiful in terms of our discussion, again, in terms of this. Listen, it's also important for you to understand that if we have to be internationally honest. So this demands that we have to state, for example, the strongest version of the argument that ADR is actually Ubuntu before I start actually dismantling it in terms of its sufficiency in that context. Yes? Listen. Now also, the most powerful point of convergence is restorative intent. Yeah, both Ubuntu jurisprudence and ADR, especially mediation and even traditional processes, are actually oriented towards the legal victory of one party, but forward repairing what has been broken. Yeah, and you look at Uganda versus Senkura, which is the 2004 case. The High Court, for example, in sentencing, gave considerable weight to the fact that the accused had made reparations to the victim's family and been, received back to the community through a traditional ceremony. When you look at what Justice Remy Kasule said, he observed that the restoration of social relationship was actually a legitimate sentencing consideration. So this straightforwardly, in terms of Ubuntu consonant, and it arrived through a quasi-ADR pathway. That is something important as well and beautiful in light of the discussion. But also, when you look at the LC court system, this perhaps is the most structurally Ubuntu institutional in terms of Uganda's formal legal structure. When you look at Justice Rutaya versus Starring Civil Engineering Company, which was, I think, a 2002 case, the Court of Appeal confirmed that the LC's proceedings, though informal, carry legal weight where they actually reflect genuine communal relation and even consensus. So the LC's court structure, in terms of community members, adjudicating disputes of the community members, with emphasis on restoration of neighborhood relationships, mirrors this kind of Ubuntu communal personhood directly, which is another beautiful thing. Again, as I said, my job is to make this distinction between the two, and that's what we're about to come to. Listen, when you look at Matoput, for example, it is arguably the purest legal expression of Ubuntu in Uganda. Yes, it addresses the same justice of question of Ubuntu that Ubuntu addresses. So how do we restore a relationship after a grievous harm, for example? How does the community heal? Or, how do we integrate the wrongdoer without actually destroying accountability? Yes. So in post-conflict Uganda context, for example, it's analyzed in the case of Thomas Choleo versus Uganda in terms of constitutional petition number 036 of 2011. The Constitutional Court grappled directly with the tension between international crimes divisions in terms of retributive framework and even the community's demand for Matoput based on restorative justice. And Justice Remy Kasule and Alfonso Winnie-Odolo, as they were then, and other acknowledged that the legitimacy of traditional justice mechanisms, even if the court ultimately deferred on the formal criminal framework. And that is something, again, we cannot again take away in terms of our discussion. Listen, you could also argue in terms of in commercial mediation under the Judicature Mediation Rules 2013, yeah, the mediator's role is explicitly facilitative, okay, not adjudicative. So the process values in terms of party voice, relationship preservations, mutual gain, and even voluntary agreements. These procedurally mirror Ubuntu's emphasis on dialogue in terms of the IDABA or even consensus and the preservation of ongoing relationship over the expression of legal victory. So in DFCU Bank Limited versus by Chad, BAT, and others, we could argue that the commercial courts inferred to mediation, which resulted in a negotiated settlement, preserving the long-standing business relationship, illustrates Ubuntu's rational, logical being served through ADR, even within a commercial context. And that is something, again, we cannot take away from our discussion in terms of the distinction between the two components. Listen, we now want to turn now to the harder and more important analysis. Why Ubuntu? Why ADR Ubuntu convergence? Why is there convergence in terms of the two? While it is sufficient, contingent, and structurally limited, and constitutionally ungrounded, those are the points that I want to look at in terms of the context of that relationability between the two components. So the most fundamental distinction is this, and this is something very important for you to understand. Ubuntu is philosophical and constitutional value. ADR is procedural mechanism. So they may produce similar outcomes in particular cases, but their normative foundations are entirely different. ADR was introduced in Uganda's judiciary primarily for efficiency reasons, to reduce the case backlog, cut judicial costs, and even accelerate dispute resolution. The Judicature Mediation Rules 2013 were promulgated against the backdrop of judiciaries groaning under the case backlog. Over 130,000 cases in Uganda from Commission. That was way back in 2013. So the motivating philosophy was managerialistic, not Ubuntu. So the fact that the mediation happens to generate outcomes consonant with Ubuntu does not mean that it's grounded in Ubuntu. You must understand that. So consider the analogy. The fact that the doctor gives a patient bed rest because the hospital is overcrowded, and that this happens to promote healing, does not mean that the doctor acted from a philosophical holistic care. Yeah, the outcome may be the same. The animating principle is entirely different. Constitutional Ubuntu requires that the animating principle, not just the outcome, be the Ubuntu. So this distinction has actually direct jurisprudential consequences. Look at Attorney General versus Major General David Jenifosa. Yeah, the Supreme Court affirmed that constitutional interpretation must be purposive, it will have to be value-leading, and courts must seek the animating spirit of constitutional provisions, not merely their literary effect. So if ADR animating spirits within the efficiency rather than Ubuntu's relational ethics, then ADR cannot substitute the constitutional Ubuntu, even where they produce similar case outcomes. That, my friend, is a very important distinction. Listen, ADR in Uganda is structurally an exception to the dominant adversarial paradigm. The baseline of Uganda's legal system remains the inherent English common law adversarial model. Parties as opponents, judge as an umpire, winner and a loser, punitive remedies, cost orders against the vanquished. ADR is permitted as an alternative, a deviation from the norm, available in certain courts and certain case types and certain stages. So Ubuntu's jurisprudence demands the inverse. Ubuntu as a constitutional norm from which specific educational principles follow. ADR cannot tell a judge how to interpret Article 20, fundamental rights, for example, and freedom, in a way informed by Ubuntu's communal dignity. ADR cannot guide the constitutional court in assessing whether a piece of legislation violates Ubuntu's relational personhood. ADR is a procedural option in civil disputes. It says nothing about constitutional rights adjudication, in terms of criminal sentencing, in terms of philosophy, in terms of economic rights, in terms of administrative justice. Look at Salvatore Abuke versus Attorney General. Yeah? The Constitutional Court struck down the witchcraft-related exile provisions of the Witchcraft Act as an unconstitutional and a degrading punishment. The court reasoned in what this would argue as a categorization of Ubuntu reasonable decision, that the dignity of the individual cannot be reduced to their alleged wrongdoing. The community's interest in reintegrating rather than permanent exile was implicit in the court's reasoning. So this reasoning could never be part of the generation of ADR. It required a constitutional analysis and animated by Ubuntu values. So ADR simply has no jurisdiction over this particular question in terms of that discussion. Okay, let's proceed. Because ADR in Uganda is not grounded in Ubuntu constitutional or even jurisprudential, its Ubuntu consonant effects are incidental and revocable. The Judicature and Mediation Rules, for example, 2013, can actually be amended by rules of committee under Section 49 of the Judicature Act. They could tomorrow be amended to introduce evaluative mediation or even restrict mediation on purely commercial disputes, or even make settlement arguments unenforceable in certain categories, for example. So none of these changes would actually require constitutional amendment because there is no constitutional Ubuntu anchor protecting the Ubuntu consonant character of the mediation framework. I don't I hope you're understanding what I'm talking about. This is serious business. Now listen, this revocability is jurisprudentially fatal to the argument that ADR substitutes for constitutional bond. A constitutional value cannot be protected by subordinate legislation. The moment Ubuntu's expression in law depends on rules that can be unmade without constitutional amendment, Ubuntu exists at the pleasure of the Rules Committee, and the position entirely is inconsistent with its claimed status as a foundational African constitutional value. When you compare this with South Africa, where Ubuntu, for example, is referenced in the constitutional epilogue and has actually been incorporated in constitutional courts as a living constitutional principle, for example, in S versus Mkwanyane, yes, and when you look at Bay versus the Magistrate, and Kelisita, for example, or even Port Elizabeth Municipality versus the various occupiers in 2004, or even Dikoko versus Bokata. In Dokoko, Justice Albey Sachs held that the defamation damages ought to be assessed in a manner that enables the parties to restore their relationship. So a directly Ubuntu-informed remedy that has constitutional authority behind it. Uganda's ADR framework lacks this constitutional grounding. It produces similar outcomes in the same cases, but without the normative authority, the interpretive compulsion, or the institutional permanency. This, my friend, is what I'm arguing in terms of Ubuntu and the law towards the constitutional dispensation for the case of Uganda. We have to make that distinction between ADR and Ubuntu. ADR in Uganda, particularly in terms of court annex mediation, was designed within the reproducers of structure of a legal system that is actually fundamentally colonial in its architecture. The adversarial trial, the professional monopoly on justice delivery, the special organization of the courtroom, the formal rules of evidence, all these remain intact. ADR operates within this colonial architecture as a pressure release valve. Yeah? So Ubuntu jurisprudence, as argued in the constitutional dispensation framework, is not merely about dispute resolution or outcomes. It is a civilization claim, a claim that African philosophical values must reshape the foundations of legal system, not merely decorate its edges. The decolonization critique is precisely that incorporating African values into a fundamental and changed colonial legal framework produces a simulacrum of transformation, not even transformation itself. Yeah? So ADR, including Matuput, with its court adjacent form, risks the same domestication. So when Matuput is actually recognized only insofar as it produces outcomes acceptable in terms of international crime division framework, as Choleo case illustrates, it is not Ubuntu constitutionalized. It is Ubuntu tolerated within the colonial legal framework that reserves the right to override it whenever it conflicts with reserved international criminal law norms. So this is exact inversion of what constitutional Ubuntu dispensation would actually require. Do you get the drip? Do you get the drive? Do you get the direction? This, my friend, is what I'm talking about. Now listen, there are three categories in terms of the typology of Ubuntu doctrinal analysis. Yeah? You could argue in terms of category 3, that where cases argue in terms of the Ubuntu absent decision within the identifiable harm that cannot be addressed through ADR at all. The harm identified in such cases is actually judicial reasoning, which disregards the rational context and even community gain. So in that way, it produces a result Ubuntu would be prohibited. So that harm occurs in the reasoning that court itself, in terms of constitutional or common law framework, the court applies. So no ADR mechanism can actually correct this. But for causation framework, they applied across Ubuntu case analysis. That is important for you to understand. So ADR cannot answer the question of constitutional case. Yeah. So the absence of Ubuntu in terms of scholarship also identifies the absence of mediation. Yeah. And this absence is constitutional value that should actually be intimate in terms of judicial reasoning across all categories of adjudication in terms of that dispensation, if you like. So I would argue also that the analysis, therefore, converges on a fundamental jurisprudential distinction that must be stated with precision. We have to argue that with precision. When you look at the application of Ubuntu in terms of procedure Ubuntu is a set of dispute resolution practices, mediation, conciliation, traditional ADR, LC courts that produce outcomes resonant with Ubuntu values. It operates at a level of how disputes are resolved. It is contextual, it is selective, it is revocable, and managerialistic in its origins in terms of that concept. So when you add in terms of constitutional Ubuntu, it is the normative principle anchored in the Constitution that all legal reasoning, rights, adjudication, legislative designs, and even executive action must actually be animated through Ubuntu values. It operates at the level of what the law is for and what it means. It is universal in application. It's entrenched against ordinary legislative change. And it talks about civilization in its ambition. Okay? That's extremely important. So these are not the same things, my friend. A legal system can have abundant procedure Ubuntu, mediation, trial courts, restorative sentences, and yet constitutionally Ubuntu absent. So Uganda is precisely such a system. It is a procedure Ubuntu in its margins and constitutional Ubuntu nowhere in its foundation. So the argument is directly analogous to the distinction between a government that happens to make decisions that respect human rights and a government constitutionally bound to respect human rights. The former provides no guarantees. The latter creates enforceable obligations in terms of Uganda's Bill of Rights. Look at Chapter 4 of the 19th Constitution. That does not merely encourage human rights respecting governance. For example, it constitutionalizes human rights, making them judicially enforceable and restraint in terms of legislative erosion. So the constitutional dispensation asks that very question, that for the same treatment of Ubuntu, ADR is at best an equivalent of a government that sometimes makes human rights respecting decisions without constitutional obligation. And that is something that I want our viewers to comprehend and understand in terms of the discussion. And that is super important. Now, for the question of more like a summary of sorts, I would argue that the answer is an ambiguous no. The two are fundamentally not the same in terms of compounding reasons that I just presented. But I would also make further emphasis when you look at the case of for example, Mwanga Chivumbi versus Attorney General as a constitutional petition number 9 of 2005. The Constitutional Court held that the provisions of the Police Act permitting detention of persons found in what? Circumstances suggesting criminal intent violated Article 23 of the Constitution. So a constitutionally embedded Ubuntu principle would have required the court to go further. Yes, to ask not merely whether the detention violated a formal right, but whether it violated the relational dignity of the detained person, whether it damaged the community fabric, whether a restorative rather than a purely procedural remedy was actually required. So ADR has no role in that case. Constitutional Ubuntu would have actually happened. Look at the case of Sehad and three others. First, the Attorney General. The constitutional petition of 16 of 2011. The Constitutional Court addressed the maternal health care as a right to health. A constitutional Ubuntu would have actually supplied the court with jurisprudential tools to read Article 33 in terms of right to win, Article 45 in terms of the rights, in a manner affirming communal obligation from what? From maternal health. So Ubuntu's understanding of health is a communal, not merely individual condition. ADR is irrelevant in terms of this analysis, and that is something you must understand again. Now listen, also fundamentally important, the Ubuntu divided index. Yes, the measurable improvement in terms of justice outcomes attributed to Ubuntu consonant reasoning requires to be maximized, that Ubuntu becomes a compulsory rather than an optional element in terms of judicial reasoning. ADR makes Ubuntu optional in dispute resolution. It says if the parties choose, they may have resolved this through a process constant with Ubuntu. Constitutional Ubuntu says in all adjudication, Ubuntu must inform reasoning. The difference between may and must, between choose and compel, is entire difference between procedural Ubuntu and constitutional Ubuntu. And that is something important, again, for us to comprehend in terms of our discussion. We could also argue in terms of what Parliament has actually done. Uganda's Parliament operates under what? Under the Constitution, without any Ubuntu interpretive constraint, legislation that can actually be even regularly enforced in terms of the enactment. And this is something that makes Ubuntu, in a way, hostile. So individualizing, for example, land tenures that ways that in terms of fragment or even communal holdings. Look at the Land Amendment Act, yeah? In the controversies, criminalizing cultural practices that serve Ubuntu retention functions, creating punitive sentencing frameworks that disregard community integration. No amount of court annex mediation can actually constrain Parliament from enacting Ubuntu hostile legislation. So because Parliament is bound by the Constitution, not by the rules of committee, so only constitutional Ubuntu can actually reach Parliament legislative power. And this is something that's really important as well in terms of our discussion. And that these are wonderful issues that you need to comprehend. Let me also take you further. When you look at Thomas Cholero, Cholero, in terms of Uganda Constitutional Petition 036 of 2011, this becomes the most powerful single piece of Ugandan jurisprudence for this argument, because Cholero, a former area commander, sought amnesty under the Amnesty Act of 2000. The Constitutional Court initially granted this. On appeal, the Supreme Court reversed. So in Uganda versus Thomas Cholero, holding that the Amnesty Act did not automatically apply and that international criminal law obligations potentially prevailed over domestic amnesty. You know, what this case reveals is the following: that the Ubuntu resonant options, amnesty, restorative justice, community integration through Matoput, was available within the legal system, yet it was ultimately overridden by former legal framework that had no constitutional Ubuntu anchor. So had Ubuntu been used constitutionally in terms of the entrenchment, then the Supreme Court would have actually required to weigh the constitutional Ubuntu value in the interpretive calculus, not merely permitted to consider that it is a policy option. So the absence of constitutional Ubuntu meant that Matoput's claims and the Ubuntu-based restorative justice demands of the affected communities in Acholiland had no constitutional standing. They were policy considerations, not constitutional imperatives. This is bad for the test, applied at the highest level of Uganda jurisprudence, but for the absence of constitutional Ubuntu. Yeah? So Cholewo's case might have been resolved through a framework that acknowledged Matoput as a constitutionally authoritative, not merely cultural tolerability in terms of that. That is something you must understand. If there is a point that I've made, that is the point in terms of that case, because it isn't operating at the highest court level. So Ubuntu's most radical jurisprudential demand is its challenge to structural violence, the systematic patterns of legal and even institutional designs that damage community, perpetuate inequality, and even frustrate human flourishing at the communal level. ADR resolves individuals or small group disputes. It cannot address the Ubuntu hostile structure of a constitutional order that lacks constitutional duty of Ubuntu solidarity. Yes, it provides no Ubuntu-informed reading of economic rights, fails to consolidate or even constitutionalize communal and even land tenure as an Ubuntu value. It offers no Ubuntu anchor on interpretations of Article 21 in terms of equality in a way that accounts for communal rather than merely individual equality. So the constitutional dispensation argument is that it's at its deepest an argument that constitution itself must be Ubuntu. ADR is a feature of dispute resolution practice. These operate entirely different levels of legal ontology. Claiming ADR makes the constitutional dispensation argument unnecessary is like claiming that Uganda's excellent weather forecast service makes a constitutional right to a clean environment unnecessary. Yeah? So the weather service may produce good outcomes in particular cases. The constitutional right addresses the structural conditions that generate the need in the first place. Are we together? Do we understand what we are talking about? That, my friend, is the proper, hyper-duper distinction between ADR and your friend called Ubuntu. And that's why I'm making a case for the constitutionalization of Ubuntu as deliberate without any. So perhaps the most surprising turn in this analysis is the existence of what they call partial success of ADR. Actually strengthens, not weakens, the constitutional dispensation argument. That logic unfolds in 5 compounding steps. Yes? ADR as Ubuntu consonant feature have demonstrably improved justice quality. Yes? So when you look at things like restorative outcomes, relationships in terms of preservations, community involvement, these have demonstrably improved justice quality in Uganda in the cases of courts where they have actually been applied. So this is empirical evidence in the commercial court, for example, in terms of settlement statistics, in terms of mediation, for example, by LC courts, in terms of community satisfaction rates. You may look at some of these provisions as well. They are documented successes in terms of Matoput in northern Uganda in terms of the post-conflict reconciliation. Then we could also argue in terms of the second step, the presentation of these arguments could be partial and selective and even contingent. Why? The improvements are limited in terms of cases that are amenable, to ADR, jurisdiction with functioning ADR structures and parties willing to engage in the processes. Then you argue in terms of the last step 3, in terms of the constitutional dispensation that asks if Ubuntu was applied anywhere else. The constitutional dispensation in terms of this argument asks what would happen if the Ubuntu values that generate these improvements in terms of ADR were constitutionally embedded and the enforcement applicable across the entire legal systems and not just ADR corridors. Yes? And I'll argue in terms of that. But also when you look at the answer in terms of a systematic, compulsory, and even transformative argument, we could draw a lot of comparative analysis from South Africa in terms of the post-Mukwane Ubuntu jurisprudence and the form of Ubuntu divided index methodology. The improvements will actually be systematic, compulsory, and even transformative rather than in a marginal, operational, or in an incremental way. That is something also must understand. So in terms of another step, you could argue that ADR is a proof of concept. The constitutional dispensation is the full deployment. You must understand that. So ADR demonstrates the value of Ubuntu in law, and the constitutional dispensation argues in terms of a seeking or seeks to expand that demonstrated value from the procedural margins of constitutional core. So ADR is the proof of concept. The constitutional dispensation is the full deployment. So you have it there in its entirety. Yeah. So for me to contextualize the argument in terms of the 3 wonderful issues that I've just been talking about, I would argue in the sense that is ADR Ubuntu partly and its best expressions authentically so, particularly in terms of traditional ADR, Matoput, LC courts, plan castles, and facilitative mediation. This resonates with Ubuntu relational ethics, restorative orientation, for example, communal harmony that are genuine and jurisprudentially significant. Now, why is it not fully Ubuntu? It's because it's animating philosophy of efficiency, not Ubuntu, because it operates at a procedural margins rather than constitutional core, because its Ubuntu consonant effects are actually incidental and revocable, because it cannot bind courts to constitutional adjudication, parliament in legislation, or even the executive in governance, and because it produces colonial legal architecture rather than decolonizing it. That is the point I'm trying to make here, my friend. I hope we are together. Okay, so does Ubuntu, ADR's Ubuntu consonants make constitutional representation argument unnecessary? Categorically no. Their reasons are not merely academic. Uganda owns jurisprudence from, look at the case of Obuki to Cholewo, look at Seha to Mwanga. It demonstrates with painful clarity that Ubuntu consonant outcomes are achievable but not granted. It recognized but not entrenched, available but not compelled. The constitutional interpretation argument addresses exactly those gaps. The gap between the legal system that sometimes produces Ubuntu outcomes and one that constitutionally is bound to do so. That, my friend, is the discussion that I want us to be in super agreement with, because that informs perhaps the distinction between Ubuntu and this good, beautiful thing called ADR. Okay, thank you, my friends. Thank you for listening. I appreciate the discussion. We shall have another shorter discussion next time. God bless you.